Hi, my name is John Botha, and I head up the people function in the Adcorp group. I've been very involved in the amendments to the Labour Relations Act, spent 6 years at LAC, and obviously have been very involved in the implementation of the amendments to the LRA in 2015. Today we're going to take a look at the Labour Appeal Court judgment around the assigned services matter. This judgment has evoked a huge amount of debate and discussion, simply because it addresses one of the most important matters in Section 198, which refers to the deeming provision. The deeming provision addresses the rights and obligations of companies and their staff members after 3 months have elapsed on fixed-term contracts. And the whole intention is to look at the post 3 month period and people earning less than 205,000 Rand per annum. Interestingly, when the assigned services judgment first went to the CCMA in 2015, the CCMA found that after 3 months, the client is the sole employer of the temporary worker. Now, this was a decision that was contested and taken on appeal to the Labour Court, in 2015 as well, later that year. Martin Brassey, who's one of the most highly regarded labour law practitioners, presided over the matter, and Martin Brassey found that after 3 months, temporary employees assigned by temporary employment services to their clients are indeed employees of both the client and the temporary employment service after 3 months. What this then means is that the temporary employment service remains the primary employer, running the payroll, recruiting, attending to labour relations matters and the like, but that the client would be a co-respondent in the event that the temporary employment service contravened the provisions of labour law. So this dual employment relationship judgment was broadly seen and widely seen to be the right interpretation of the deeming provision, because the whole intention was exactly that, to give greater protection to employees after 3 months, and greater in this context means that these employees could take action against either the TS or the client, or both jointly. In addition to that, of course, equal treatment and fair dismissal procedures apply, thereby putting temporary employees effectively on the same standing and the same footing as their permanent counterparts. What then happened was the matter was taken on appeal by NUMSA to the Labour Appeal Court. And the Labour Appeal Court then pronounced that it believed after 3 months the sole employer relationship applied. So in other words, we reverted in principle back to the old CCMA decision that after 3 months there's only one employer, in other words, the client. The problem that we have with this judgment, besides the fact that technically it has significant shortcomings, is that in the Labour Appeal Court decision, it admits that there's no Section 197 transfer from the TS to the client after 3 months. In fact, what it says is that a statutory employment relationship between the client and the assignee is created. The problem that this creates at law is that there is no provision for this transfer. During the first 3 months, temporary assignees accrue annual leave rights, temporary assignees accrue various employment terms in their first 3 months. So if there's no Section 197, the first problem would be that they then forfeit their accrued rights that they've acquired in the first 3 months. The second problem is a more material problem, in that if there's no Section 197, it's nothing short of a miracle that occurs at midnight on the end of the first 3 months, when this temporary employee is literally raptured out of the temporary employment services payroll and beamed down into the client's payroll at 1 minute past 12 on the last day of the third month. And the reason that's problematic is, even from a practical point of view, there's been no pre-engagement with this particular temporary assignee. There's been no assessment of pre-existing conditions in respect of registering them on the new employer, i.e. the client's medical aid or pension fund, and quite frankly, it's just doesn't make sense at law nor practically. One of the big ticket items that that business have put on the table in taking this matter on review, or rather appeal finally to the Constitutional Court, is the fact that the Labour Appeal Court decision creates disharmony amongst the other labour laws. So in other words, the Labour Appeal Court only has the right to interpret legislation. It does not have the right to create legislation. And effectively, by saying that the client is the only employer after 3 months, the Labour Appeal Court has overridden various other laws. For example, the Basic Conditions of Employment Act hasn't been amended, and the BCA still sees the Temporary Employment Service as the only employer, even after 3 months. The same principle applies to the Skills Development Levies Act, as well as, for example, to income tax legislation, where PAYE is still deducted and paid over by the Temporary Employment Service. The problem, therefore, colleagues, lies in the fact that the Labour Appeal Court has exceeded its powers, it's created disharmony, and therefore the Constitutional Court must hear the matter because Section 23 of the Constitution calls for fair labour practices. And effectively, the Labour Appeal Court has undermined that, besides the fact that it's totally ignored the other labour laws. Just one example of a technical reason why the Labour Appeal Court judgment is incorrect and why there should be a dual employment relationship after 3 months lies in the very wording of Section 198 for capital A. Colleagues, what that section allows, it allows for a temporary assignee to litigate either against the client or against the TES or both. Furthermore, it allows a labour inspector to enforce a compliance order either against the client or the TES or both. It stands to reason and very clear then that after 3 months there have to be two parties to this employment relationship, or else the words either or both can't be applied if there's only one employer. Along a similar trend is the fact that after 3 months temporary employees earning below the threshold are entitled to equal treatment. The Act requires that on the whole, temporary employees should not be paid less than their permanent counterparts. Why then would the Act have put equal treatment in as a right if after 3 months there was only one employer? Quite frankly, there would then not be a need at all to ensure equal treatment, because they'd all be on the same pension funds, medical aids, grading schemes, and the like. So the Labour Appeal Court, with respect, has made a significant error in respect of its findings. A number of people then ask, what about the Constitutional Court matter? What are the variables that we need to consider? Well, the first thing is that the application for leave to appeal to the Constitutional Court was submitted on the 31st of July this year. That was within the 3-week time period that business was allowed to take the matter on appeal to the Constitutional Court. The net effect of that is simply that the Labour Appeal Court judgment is stayed until the Constitutional Court has pronounced on the matter. What it effectively means is that Martin Brassey's dual employment relationship judgment stays in effect according to Section 18.1 of the Superior Courts Act. Section 18.1 basically states that unless the Labour Appeal Court determines otherwise, the Labour Appeal Court judgment is stayed until the Constitutional Court has decided. There are many other reasons why that is the case, such as also Section 18, subsection 3 of the Superior Courts Act, which states that we need to implement the version of the finding that has the least harm to the parties. In other words, if we were to pull temporary employment services out of the equation now, before the Constitutional Court case is heard, and suppose that the Constitutional Court case finds in favour of dual employment, it would then be too late to suddenly reinstate the very temporary employees who've been removed. So the balance of harm would definitely favour keeping the status quo, having a dual employment relationship, and waiting for the outcome of the Constitutional Court matter. The other question is the Constitutional Court appeal, while we're waiting for it to take place, which by the way has been set down now for the 22nd of February next year. We will then wait for 4 months for a judgment to be issued by the Constitutional Court. So, ladies and gentlemen, between now and the middle of next year, the dual employment relationship applies, and it applies to all stakeholders, including the CCMA, simply because the CCMA is a party to these proceedings. It has been cited as a respondent, and in addition, the principles of the law will be argued as they stand in Brassey's judgment. Before I move on, I also just want to iterate that there's a broad view that even if the constitutional appeal was not lodged, even if the LAC judgment prevailed, there would still be no material impact on the ability of clients to use temporary employment services. And the reasons are as follows. As I stated earlier, the Basic Conditions of Employment Act is the act which requires an employment contract between an employer and an employee. And it's the BCA which makes no bones about the fact that the TES remains the employer before 3 months, after 3 months, and indefinitely. So from that point of view, contracts of employment, the running of payrolls, the paying over of taxes can all continue, even under the Labour Appeal Court decision. All that would be required is for clients who want to then use temporary employment services on a broader basis, such as attending to labour relations matters, disciplinary matters, and the like. They'd only be required to sign an addendum to the Labour Relations Act, where a type of power of attorney is given to the temporary employment service to assume the responsibilities of the client on these matters. So, ladies and gentlemen, effectively, we believe it's business as usual. The Constitutional Court judgment will be out in the second quarter of next year. And for the reasons I have mentioned, we are very upbeat and bullish in respect of the potential outcome. We have no doubt that after 3 months, temporary employees will have the right to litigate against either the client or the TS or both. And we also have very little doubt that the temporary employment service will remain the primary employer for the reasons that I have shared with you. I think in closing, also just to highlight that companies should not become fixated on this Labour Appeal Court and deeming matter. Companies are organizations that have got long-term strategies, they've got a culture, they've got value systems, and they've got to do what's best for their shareholders. In this uncertain environment, we need the ability as companies to match costs to revenue. We need to have the certainty of mobilizing and demobilizing talent with all the technological change and the skill sets requirements, and also the GDP of the country being very volatile. We need to ensure that we have the necessary flexibility through third parties in order to ensure that we cut our cloth according to our budgets. The other reason businesses often use outsourced labor or temporary employment services, of course, has got to do with other business drivers. For example, the balance sheet strength of a temporary employment service, its expertise in running payrolls and the economies of scale that it can offer clients. The fact that by procuring significant spend through majority black-owned TESs and more than 30% black women-owned TESs, that has got a lot of influence on clients' preferential procurement statuses. So, colleagues, the reality is that the tail mustn't wag the dog here. You've got a business to run, and you need to run that business in line with the strategy, in line with principles of sustainability as King 4 requires. And ultimately, although there are many, many stakeholders whose interests need to be balanced, you are a business for profit, and businesses for profit must do just that in order to survive and give employment. They need to make a profit. Workforce spend is a big part of your expenses, and therefore your ability to optimize this will determine your differentiation in the market. In closing, maybe just to share with you an analogy of a salami that gets cut systematically. So as people want to eat parts of your salami, you slice pieces off. Before you know it, of course, there's not much left. The salami in our country is unfortunately indicative of employment. Although we have significant unemployment currently at 27+%, the unfortunate reality is that there are many costs directly and indirectly linked to payroll and to headcount size. And it's in context of this that some companies pay 43 cents in the rand extra by virtue of direct permanent employment compared to flexible workforce solutions. And this is unfortunate because if you take a look at the unemployment statistics as given by Stats South Africa, every time there's been a major review of labour law and flexibility gets undermined, there's been a significant increase in unemployment rates coupled with a significant decrease in economic growth. It's with this in mind that we extend an invitation to you to engage with us in this regard. We believe that temporary employment services are one of the greatest facilitators of employment creation, that the ability to have flexible workforces introduces a lot of youth and outsiders into the labour market. And more importantly, in your context, we believe that our workforce solutions, which span independent contracting solutions, temporary employment services, direct employment models, functional outsourcing, cleaning services, and many more models, will support you in achieving your business strategies and outcomes. So the invitation is to contact your Adcorp representative, certainly, or in the context of Kelly Quest, you're welcome to drop an email to marketing@quest.co.za, and alternatively to get in touch with the Quest or Adcorp representative who's been assigned to your account. If there are any further questions, please do drop us a note and we will do further of these updates. Thank you very much.